Two. Who seeks recognition?
Mr. Chairman, I have an amendment at the desk.
Reserved point of order, Mr. Chairman.
Point of order reserved by the gentleman may state his, or excuse me, the clerk will report.
Amendment to the amendment in the nature of a substitute.
Without objection, the amendment be considered as read. The gentleman is recognized to explain his amendment.
So, genital mutilation is abhorrent. I'm against it. I know that the author of this bill has the best intentions. But I'm concerned that the interstate nexus, as it's painted here, is overly broad. It may not even hold up in courts. And so what I'm trying to do here with this amendment is tighten the definition of the interstate nexus such that we have a legitimate federal role here. Child abuse is the subject of state law. If you abuse a child, you're breaking state laws and you go to a state court. And we are here at the federal law trying to prevent something from happening, which, without a federal nexus, is the venue of state law. So there are instances where there can be a federal nexus, where this would be a legitimate legislative exercise, and that would be if we were legislating for the District of Columbia, territories or possessions of the United States, special maritime and territorial jurisdictions, somebody who's working for the federal government, for instance, that would be the second federal nexus. There's 4 that I'm prescribing here in this amendment. Instead of, in the bill itself, there's several nexuses, including if you used an instrument that had traveled in interstate commerce. Let's say a scalpel, not to be too graphic here. But there's almost no way to avoid the federal nexus as it's drafted here. So it's really, the bill itself acknowledges federalism and the 10th Amendment, but then it draws the federal nexus so broadly that it ignores federalism in the 10th Amendment. So in any case, getting back to the sections where I do believe we have federal jurisdiction, it would be any of the federal territories, it would be any individual working for the federal government or under color of federal law. It would be if the procedure was performed by an individual entity or institution receiving direct federal funding, such as Medicaid, Medicare, or involving the transportation of a minor across state lines for the purpose of performing genital or bodily mutilation or chemical castration. This mirrors the language, if you go and look at federal laws that exist on the books, how they come up with a federal nexus for sexual exploitation, for pornography. The pornography has to be involved, actually be transported across interstate lines. But this is more analogous to sexual abuse, which involves, or rape, which would, of a minor, which has to involve transportation of the minor across state lines. Again, I think it's a good bill. I'm glad that it acknowledges that there has to be a federal nexus. I think the federal nexus that's drawn here in the bill itself is too broad and doesn't mirror the legislation that's on the books, analogous legislation. And so that's why I'm offering this amendment, to tighten the language. And with that, I yield back. I would also add, let me just say, we often don't get into, try not to assign motives to our colleagues, so I'll assign my own motive here to why I'm offering this amendment. I can't vote for the bill itself unless it's modified in this way, and so in good faith, I have to offer a way to fix my objection. This is the objection I have, and this is the fix that I propose.
Gentleman insists on his point of order.
Yeah, no.
The question is on the amendment offered by the gentleman from Kentucky. All those in favor?
Mr. Chairman.
No, all those I'm just calling the roll. I didn't think you guys, all those in favor say aye.
Mr. Chairman,
I think
want to discuss the amendment.
Gentleman's recognized.
I just want to agree with the gentleman from Kentucky. We can sit here and we can go into great detail, as everyone on this committee, particularly on this side of the aisle, knows, about the abuse under the Commerce Clause of federal power. And as a party that stands for the proposition of limited government, we are careful about the use, or we should be careful about the use of the Commerce Clause to carry out the power of the federal government and to create crimes. And so here we're talking about the language that is always used in terms of the instrumentalities of commerce and so forth, which is typically used to be able to use the Commerce Clause to apply the power of the federal government against the state or actors within a state. So here, what the gentleman from Kentucky is doing is trying to outline what he believes is appropriate nexus, as he used the term, which is the territories in the District of Columbia, as well as children who have crossed state lines, and then another category about those hospitals or healthcare providers that are taking federal dollars. Now, I think that is a better approach. I think it is important for us to recognize that we have now, since Wickard v. Filburn, we have abused the Commerce Clause so much as to eliminate any recognition at all of the balance of power between the federal government and the state government. And that is the point. And we've all been guilty of it. It's the same thing that Republicans do when we campaign on balanced budgets and come here and spend money we don't have. It's the same thing that we do when we go out and try to talk about limited government, when we then vote for all of the laws and all of the regulations and all of the rules that we then campaign against. So here, what we're trying to do is tighten down and acknowledge the truth, which is that we are all aghast at what we're talking about with respect to these policies. Chloe Cole sat at that table and testified in this room to this committee, might have been the subcommittee, in explaining the extent to which her life was turned upside down by these horrific procedures. These procedures should be outlawed. These procedures on minors are grotesque, and the doctors that carry them out should be ashamed. And the doctors that are carrying them out, often against state law and using funds they shouldn't use, should be ashamed. But at some point, we in this committee have got to be the guardians of the Constitution and the limits of the power of the federal government and how it is used. And so we should focus and target the use of that power, especially and carefully. That is why this amendment is being offered, and that's why I support the amendment being offered by the gentleman from Kentucky. And yield back, or you want to? And I now yield back.
Gentleman is back. Gentleman from Maryland is recognized.
Thank you, Mr. Chairman. Well, the gentleman presents us with a bit of a dilemma here, because we think that the whole bill is a dreadful invasion of the regulatory authority of the states, the medical boards and commissions in the states, and the families and the parents who should be making these decisions under our constitutional system of government, where the people have rights guaranteed to the people and the states under the 9th and 10th Amendments. Nonetheless, I would say that the gentleman's amendment does narrow the bill significantly, I think, because there will be some people who will actually be able to make decisions for their children still after this amendment, and there will be some people, some hospitals and doctors who will be able to continue to practice the best practices of the profession. I wish that the gentleman from Texas would go all the way. When it came to COVID-19, he said the American people are fully capable of making an educated decision about whether they want to get the vaccine or not. But under the logic of this bill, which he seems to be supporting, it would be fine for the federal government to say, at least where there's a federal nexus as defined by the gentleman, that we're going to override the judgment of the parents and say it's in the best interest of the kids to get the COVID vaccine, or in a hypothetical perhaps a bit closer to home, get the measles vaccine, We lost 1.2 million people in COVID-19. We've lost millions of people to measles. I think there's a much better argument for that. We're not talking about putting other people at risk and danger because of a contagious disease. This is a decision for the family itself. And yet, you want to override all of the decisions of the family, the best wisdom of the medical profession, the state boards, and the state laws to do this. But having said that, my friend Mr. Roy at least makes a gesture at trying to torture out some kind of federal nexus to the conduct that is being proscribed here. I'm not quite sure why the District of Columbia is treated like a federal enclave. It's not a federal enclave. It's the district that's the seat of government. And I wonder if he would, in the future, extend the logic of applying a nationwide mandate to anybody getting federal funding. Nonetheless, I'm going to go ahead and vote for this. I'll leave it to the judgment of my colleagues whether they will want to, but I do think that it narrows the scope of this really terrible bill.
We have votes called on the floor. The question occurs on the amendment offered by the gentleman from Kentucky. All those in favor say aye.
Aye.
Those opposed, no.
No.
In the opinion of the chairs, the noes have it.
Can we have a recorded vote, please, Mr. Chair?
Order vote being requested. Clerk, call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Issa votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Massie?
Aye.
Mr. Massie votes aye. Mr. Roy?
Aye.
Mr. Roy votes aye. Mr. Fitzgerald? Mr. Klein? Mr. Klein votes no. Mr. Gooden? Mr. Van Drew? Mr. Nels? Mr. Moore? Mr. Moore votes no. Mr. Kiley? Mr. Kiley votes no. Ms. Hageman?
Screenshots now.
Ms. Hageman votes no. Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Fry votes no. Mr. Grothman? Mr. Grothman votes no. Mr. Knott? Mr. Harris? Mr. Harris votes no. Mr. Onder? Mr. Onder votes no. Mr. Schmidt? Mr. Schmidt votes no. Mr. Gill? Mr. Gill votes no. Mr. Baumgartner? Mr. Baumgartner votes no. Mr. Raskin?
Aye.
Mr. Raskin votes aye. Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Mr. Cohen? Mr. Johnson? Mr. Johnson votes aye. Mr. Swalwell? Mr. Liu?
Got votes now.
Ms. Jayapal? Ms. Jayapal votes aye. Mr. Correa? Ms. Scanlon? Mr. Neguse? Ms. McBath? Ms. Ross? Ms. Ross votes aye. Ms. Ballant? Ms. Ballant votes aye. Mr. Garcia? Mr. Garcia votes aye. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes aye. Mr. Moskowitz? Mr. Goldman? Ms. Crockett? Ms. Crockett votes aye.
Clerk will report. We already won. It doesn't matter. We already won.
Mr. Knott? Mr. Knott votes aye.
Mr. Knott? Mr. Knott?
We gotta call the freaking roll. Clerk will report. Clerk will report. Votes are in.
Mr. Chairman, there are 13 ayes and 15 noes.
The amendment is not agreed to. We will stand in recess, come back for hopefully vote on final passage while we go vote on the floor.
We could voice.
We got anything? Oh,
Let's do it.
no, you guys, you got done with amendments? Let's. Question occurs on the on the amendment, the nature of a substitute. This will be followed by a vote on the amendment on the final passage. Clerk will call the roll.
The question occurs.
Question occurs. All those in favor say aye. Aye. Those opposed, no.
No.
In the opinion of the chair.
Opinion chairs, the ayes have it.
The ANS is adopted.
ANS is adopted. The question now occurs
Can we record a vote on that?
On the ANS.
you know, on the final bill.
Yeah.
Okay. Question now occurs on the final bill. All those in favor say aye. Those opposed, no. Opinion of the chairs, the ayes have it.
Recorded vote, please.
Clerk will call the roll.
Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Issa? Mr. Issa votes yes. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Mr. Tiffany? Mr. Massie? Mr. Roy? Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Klein? Mr. Klein votes aye. Mr. Gooden? Mr. Van Drew? Mr. Nels? Mr. Moore? Mr. Moore votes aye. Mr. Kiley? Mr. Kiley votes aye. Ms. Hageman? Ms. Hageman votes aye. Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Fry votes aye. Mr. Grothman? Mr. Grothman votes aye. Mr. Knott? Mr. Knott votes aye. Mr. Harris? Mr. Harris votes aye. Mr. Onder? Mr. Onder votes aye. Mr. Schmidt? Mr. Schmidt votes aye. Mr. Gill? Mr. Gill votes aye. Mr. Baumgartner? Mr. Baumgartner votes aye. Mr. Raskin? Mr. Raskin votes no. Mr. Nadler? Mr. Nadler votes no. Ms. Lofgren? Ms. Lofgren votes no. Mr. Cohen? Mr. Johnson? Mr. Johnson votes no. Mr. Swalwell? Mr. Liu? Ms. Jayapal? Ms. Jayapal votes no. Mr. Correa? Ms. Scanlon? Mr. Neguse? Ms. McBath? Ms. Ross? Ms. Ross votes no. Ms. Ballant? Ms. Ballant votes no. Mr. Garcia? Mr. Garcia votes no. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes no. Mr. Moskowitz? Mr. Goldman? Ms. Crockett? Ms. Crockett votes no. Mr. Chairman, there are 17 ayes and 10 noes.
Members will have 2 days, to submit views without objection. The bill will report as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Gentleman from Wisconsin wanted to make a statement. Gentleman is recognized.
Yeah, on this bill, I got here a little late, said another hearing. I don't understand, and I hope we change this before it hits the floor. In our society, a lot of times we say things has to be done at 18, sometimes 21. This should be age 55, but if we're going to pick between 18 and 21, I don't know who would say this is appropriate for a 19-year-old. So I hope we change it to 21 when it gets to the floor. Thank you.
Gentleman yields back. This concludes the committee's business for the meeting. The meeting is adjourned.